anti-counterfeiting trade agreement and their relation, and how are they governing the protection of digital rights management. ACTA is creating new intellectual property enforcement standards which are more stringent than the international forums such as WIPO and World Trade Organization. These negotiations take place secretly and not in open international forums as the negotiations which take place in other international forums such as WIPO and WTO. Through this agreement, the countries aim to increase the authorities of the law enforcement agencies to prohibit digital infringement activities. This agreement was negotiated from 2007 to 2010 but was only ratified by Japan. IP enforcement provisions, that is the intellectual property enforcement provisions to protect online internet service providers by promoting blocking of content and filtering of information. ISPs are provided to block and filter the information so that only a refined or a set of information is delivered to the end user, which is legal and which the authority wants to provide to the end user. This imposes criminal penalties for promoting copyright infringement. This treaty has very stringent provisions and therefore it has been rejected by Europe in 2012. United States Digital Millennium Copyright Act. The DRM provisions of the WIPO Internet treaties were successfully implemented by US under the DMCA in the year 1998. Provisions under DMCA to protect DRM are: these clearly distinguish between the protection for technological measures that control access to work and protection for measures that control use of a work. So there's this major distinction which is clearly given in the given statutes. Access control provisions also aim to prevent proprietary activities like manufacture and distribution of tools that are primarily meant for facilitating circumvention of access control. Furthermore, anti-circumvention provisions relating to protection of usage control measures prohibit only preparatory activities. Exemption provisions are also given under the DMCA. They serve the purpose of encryption, research, law enforcement and security related government activities. Civil as well as criminal remedies are there under the statute for violation of anti-circumvention provisions. Now I would like to discuss some of the Digital Millennium Copyright Act cases. First one is the Marvel versus NCSoft. In this case, Marvel is suing NCSoft and Cryptic makers who have a massive platform, who have a huge platform of online games for copyright and trademark infringement. Marvel has claimed that because players in the games who create superhero characters to send on in-game missions can make characters that look like Wolverine or the Incredible Hulk. So basically the players who create the superheroes look like the superheroes look like Wolverine and Incredible Hulk. So the creation which is being done through the medium of digital rights management are contributing to players' infringement. RIAA versus Charter Communication Archive. The RIAA sought to force the Missouri ISP Charter Communication to turn over the identities of its customers who the RIAA believed had engaged in peer-to-peer file sharing. All those network of devices which are connected in a single network, the different users who are connected in the network are trying to access the content, ebooks, their content and other online material via peer-to-peer file sharing, which is also prohibited, which is unethical. There are more cases. Chamberlain Group versus Skylink Technologies, fighting the abuse of copyright law to stifle competition. EFF helped Skylink score a very important victory in the Federal Circuit that puts much needed limits on the controversial anti-circumvention provision of DMCA. Chamberlain is a manufacturer of garage doors. It invoked the provision to stop Skylink from selling a universal remote that works with Chamberlain garage doors. The court rejected because these provisions were stifling the competition, noting that if it adopted company's interpretation of DMCA, it would threaten many legitimate users of software within electronic and computer products. So this was anti-competitive, something the law must aim to protect. Lexmark versus Static Control Case Archive. EFF helped defend a printer cartridge company against a competitor's overreaching copyright claims under the DMCA. Lexmark actually brought a lawsuit against Static Control in an effort to eliminate the market for remanufactured or refilled toner cartridges, because if it had not stopped them, they would be manufacturing or producing or refilling the cartridges, which would again be anti-competitive. So in order to protect their own brand for their own protection measure and to stop this piracy, they fought a case against Static Control Case Archive. Now I'm going to talk about the EU Copyright Directive, which is also known as the Information Security Directive of 2001. It was formulated with an attempt to harmonize the copyright law within the European Union. But still, the different member states implement their own national copyright laws in different languages and with certain flexible and different provisions. But they definitely try to formulate the provisions of the Information Security Directive in their own national legislation. Article 6 of the directive makes it necessary for the member states to provide adequate legal protection and solutions against the circumvention of technological protection measures, also known as TPMs. These are the provisions basically which are given to protect, which are formulated in the Information Society Directive to protect digital rights management. Furthermore, Article 7 of the directive prohibits the tampering and stifling of the rights management information, dealing in such infringed works when the person engaged in such acts as inducing, enabling, or facilitating infringement of copyrights through such actions, such as hacking or piracy, basically. It also prohibits many activities of commercial nature with respect to circumvention of technological protection measures. The issues here with the implementation of Information Society Directive are: none of the member states have provided an express right, an exclusive right for users to circumvent the technological measures for non-infringing purposes. So basically, the interests more or less many a times lie in the balances or goes in the favor of the rights of the owner of the rights, since the copyright regime implemented by different member states is diverse in different languages with different provisions. The users of information in cases of exceptions have to reach out either to the court, that is the law enforcement agency, or the concerned authorities in the absence of the right holders or the courts. So here the issue is that the copyright provisions for different member states in the European Union are so different and diverse that if a user has to access some information online, and that information is only available in a limited manner, or is restricted, or if he or she wants to access that information, he has to basically first and foremost go and take the permission of either the law enforcement agencies or the copyright holder. So not in all the cases it can be possible that the end user goes up to the right holder to access even a little amount of or a limited amount of information. There are many other digital rights management provisions which are anti-progressive, and there have been serious issues raised over freedom of speech, scientific research, innovation, competition in the market, fair use, which balance the entire digital system between the interests of the right holders and the users.